If the will is being contested, whose fault is it? The client himself, the financial advisor, or the will writer? Or is it the will writing company or the law firm? I give you an example. Client has done a will, and the contents of the will is 90% goes to wife, 10% to mom. He passed away in 2025. In another word, upon his death, the wife wants to buy over the mother-in-law's share, the 10% share. The only issue is she going to buy over at market price, or will the mother-in-law sell off her share to her at a gift of $1? But whatever the case is, stamp duty will have to pay. So whose fault? The client? After all, will is the client's wishes. Well, it will be the client's fault if the will is done by client himself. But like most clients, most people are laymen, they don't know the law. They depend on professional people like the will writer. So it is not the client's fault. What about the will writing company? Well, the will writing company or the law firm, no, it's not their fault. Okay, particular if that will writer and the relationship between the will writer and the will writing company is a agent, like order taker, and they just pass the information to the will writing company. The will writing company just prepare according to what was given instructions by the will writer. Then it can't be the law firm or the will writing company's fault, because it's not an employee, it's a more commission based. Okay, so such a thing, it is not the will writing company, nor the software. You can't blame the software, right? It is whoever type inside. No, but then again, who type inside is depend on the intermediate person that interact with the client. In another word, the fault lies a lot on the financial advisor who call themselves a will writer, or the will writer, the person in between, that helps the client to plan ahead. They should be the one that should have the knowledge to be able to help the client. Now, going back to the example, could that stamp duty, which is going to cost quite a lot depending on the value of the company, the value of the property, could it be saved? Yes, could have been saved if, assuming cash component is given part of it to the mom, then it's because it's cash, it's easier to split. Then there's no stamp duty because it's not, it's not property, right? But when there's a property transaction, there is a stamp duty incurred. So I would say this, and I would encourage this to all the financial advisor and will writer. Okay, get yourself properly equipped with knowledge, right? Because I've seen cases whereby the will writer, the one who interact with the client, at times is lawyer themselves, has been sued when the will is being contested. So don't get yourself involved, and being arrow being pointed at you, if given the wrong advice. Okay. By the way, as a will writer, okay, or the financial advisor, will is a legal matter, right? You should not be giving advice. Yes, you are not in a position to give legal advice pertaining to the will, right? On the other hand, what you can do is share ideas with client, and client decide for themselves what need to written inside the will. Yeah. So whose fault? The answer is pretty obvious. It will be the one who interact with the client and help them to plan the content. So get yourself a knowledge, get yourself equipped with the knowledge of the law, so that basically you can help your client to plan out the will proper. This is Richard Yeo from Prohibited Enterprise. Thank you.